An expunged record at the state level may not be enough to qualify for military service. A federal appeals court says the service branches can enforce stricter enlistment standards than those set by the Defense Department and don't have to honor state expungements when evaluating potential recruits. Federal News Network's Anastasia Obis spoke to Ira Rushing, associate with Tully Rinckey, about how the court's decision could impact current service members or potential recruits.
This is a state court case that came out of the Seventh Circuit that eventually got appealed up to the Seventh Circuit. And so the issue was that Eric Smith, who was a plaintiff, used to be in the Army. He was an Army Reserve member, and he wanted to re-enlist in Indiana after he had gotten out, but subsequently got convicted of felony arson. And after some time, he got that felony arson conviction expunged. So he went to go re-enlist into the Army, and the Army denied the re-enlistment. They basically said, look, felony is major misconduct, right? So under the Army recruiting regulations, we're not going to grant you a waiver, which in any case, a felony requires a waiver. And the Army is the most liberal of all the branches. They normally do a couple of hundred felony waivers every year. So he sued the Army and basically said, I'm suing you in your official capacities under the Administrative Procedures Act, which is what kind of the framework that you have to sue the Army and the government a lot of times. Basically saying, look, this denial is arbitrary and capricious, right, which is that standard. And Indiana code says, or Indiana law says that I can't have employment consequences. You can't not hire me for expunged convictions. And ultimately, that court granted summary judgment for the Army, where they just said, hey, look, there's nothing here. The Army has the ability to do that. Then Smith appealed it up to the Seventh Circuit. And what he did in the appeal is he tried to readjust it and reframe the argument as basically saying, hey, look, I'm going to challenge the Army's recruiting regulations. Basically saying the Army's regulations exceed the DOD, the Department of Defense's authority, and y'all disregarding my expungement was unlawful. The Seventh Circuit agreed with the district court and just said, look, the Army has the ability to do that. They're consistent with their regulations. And ultimately, the federal statutes and Department of Defense, they don't have to look at state court actions at all. You know, it's federal stuff. It's federal court, federal administrative procedure. So whatever happened in his state doesn't matter. So that's essentially what has happened in the case.
You mentioned that the Army is the most liberal of the service branches. Could applicants see different outcomes depending on which service branch they apply to, given this decision?
Absolutely. I want to say last year the Army granted something like a little bit more than 400 felony waivers, but it's totally up to the discretion of the Army. It depends on what the conviction was for. It matters when it was. What we tell people at our firm is when we're building waiver packages for people who are trying to join the military and they know they've got this issue, or maybe they've tried to join and the Army or one of the other branches has already come back initially and said no, is get letters of recommendation from community leaders, educators, law enforcement. If you can get a letter from the sentencing judge or the prosecuting attorney, that's really persuasive for the Army to want to accept that risk, but they don't have to. It depends, right? I know the Marine Corps doesn't care as much about some felonies as it does other because it wants to recruit a certain level of candidate to join the Marine Corps. The Coast Guard is completely different. The Air Force is completely different. It's up to each individual branch to set its own regulations, and the authority to do that has been delegated down to them. So, and often it comes to the initial denials come from kind of local regional areas, but then certain felonies have a higher approval authority to grant the waiver, and it could be as simple as hey, we just don't want to deal with it. We don't want to ask this general for permission to get you to join. It's too much hassle or whatever. I'm not saying that's true in his case, but it could very well be the issue.
Speaking of waivers, does this decision make waivers harder to obtain for applicants with prior misconduct?
No, this actually doesn't do anything for applicants with waivers because it's not changing the law. All it's doing is drawing attention to the system as it's worked for a long, long time. There's a process for applying to waivers, and I think the process works. I mean, there's some policy tension here. States increasingly expand expungement and clean slate laws to facilitate kind of reentry and really rehabilitation in that state's system. But the military remains, and I think appropriately so, with broad discretion to determine who is fit to serve. Military service is a privilege. It's not a constitutional right. I think the services have to balance readiness and good order and discipline and security requirements against the individual's interest in serving. So I think anybody out there that has a felony or anything else that is going to require a waiver to join isn't put off by this case, because this case isn't changing anything. It just, if anything, highlights the need for getting maybe outside counsel or getting some help in applying for and receiving that waiver. Because, once the Army has said no to Smith, he's pretty much done in the Army. It doesn't mean he can't apply to the other branches, but he shot his shot with the Army and it didn't work out. And one could make the argument if his waiver package was put together a little bit better, maybe it would have a different outcome. So I don't think it necessarily affects other applicants who need a waiver. I think it just highlights that they need to do it the right way.
You touched on it a little bit, but I'm curious if you expect future legal challenges in how the military treats expunged convictions. Could we see pressure from states to align federal enlistment rules with state expungement laws?
I think so. And I was thinking about this when I read the case, is that if I had to start this case over with, and the lawyer's dream, pick my facts and pick my plaintiff, I would look for somebody who applied for a waiver after having a felony conviction and was applying to join the National Guard of a certain state, right? So if he had joined the Indiana Army National Guard, it might have had a different outcome, because the framework in a lot of ways still falls under state law. He would be joining the Army, and obviously the Army still has the ability to grant or deny waivers and set its own expectations, but there would probably be a little bit more political pressure from the state if they knew that they were missing out on a soldier. I think that maybe you would see future challenges in that context, because, you join the Army in the National Guard and you do your training and all that. But once you come back to the state, you fall under Title 32 of the U.S. Code. You fall under the state's laws. You fall under the Indiana Code of Military Justice, not the Uniform Code of Military Justice, and you are under the leadership of the governor. Those are instances where maybe I think you would see successful initial pushback. Not to say that it won't eventually have ramifications, but I can see that being a good avenue to challenge these things.
Tully Rinckey's Ira Rushing, speaking with Federal News Network defense reporter Anastasia Obis. You can find her story at federalnewsnetwork.com.